Hello, everyone. Thank you for joining our webinar today. My name is Gina O'Connor. I'm a grant specialist in the Office of Research and Sponsored Programs. Today, I am delighted to introduce our own Dr. Kirby Fuglsby, who's the Technology Transfer Officer at USD. Kirby earned her PhD in biomedical engineering from USD and started her current position with our office almost 2 years ago. Today, she's going to tell us more about intellectual property management. Welcome, Kirby.
Thank you, Dina, for the introduction. So as a disclaimer, I'm not an attorney, so nothing in this presentation should be taken as legal advice. Okay, so the agenda today, I'm going to give an overview of intellectual property in general. Then I'm going to talk a little bit about the Bayh-Dole Act and how that relates to university tech transfer. And then also talk about the policies and procedures for intellectual property at USD, and then talk about different resources for innovation in the region. So, overview of intellectual property. So, intellectual property is a broad term which encompasses the various tangible products of inventors' creativity. So, intellectual assets are ideas, know-how, and other economically valuable information and data that has been embodied in some material form and documented. So, intellectual property includes patents, trademarks, copyrights, trade secrets, know-how, and other proprietary concepts. For example, trade secrets protect secret information. So an example would be like the Coke formula is kept as a trade secret by Coca-Cola and will be protected as a trade secret for as long as Coke keeps that secret. Trademarks protect brands. So an example would be Apple for cell phones or like the golden arches for McDonald's. Copyrights protect work of authorship. So like books, movies, drawings, other artwork. And then there's patents, and those protect functional or ornamental features. So like the swipe feature on an iPhone would be like a functional feature you could protect with a patent, or like the design of the iPhone could be an ornamental feature that you protect via patenting. So who owns IP? So this is just in general who owns intellectual property, not necessarily specific to USD. So for trade secrets, it's the one to whom the secret is of value and who maintains its secrecy. So for example, we talked about the Coke formula that is owned by the Coca-Cola company. Copyright is typically owned by the author with exceptions. Like an exception would be if a company commissions someone to create a work that falls under copyright and they have an agreement beforehand that states that the company will own the copyright instead of the author. Trademark, it's the one using the mark in commerce in connection with the goods. So Apple would own their trademark, McDonald's would own their Golden Arches trademark. Patent is the inventor, unless they sign that right away through their scope of employment, which is the case at USD. Employees do sign away their intellectual property rights for patents. So at USD, the main way we protect intellectual property is through patenting. So what is a patent? It's a grant of a property right for an invention that is novel, useful, and non-obvious. And patents grant not the right to make, use, or sell, but the right to exclude others from making, using, or selling the invention. So that's a common misconception about patents. So a patent is an exclusionary right. You can exclude others from making, using, or selling the invention. It does not give you the right to do so. And if you have a patent, you can pursue litigation against someone else that is making, using, or selling the invention. Types of patents. So there's utility patents, design patents, and plant patents. The main type of patent that USD deals with are utility patents. So that'll be what I focus on today. But utility patents protect functional aspects of an invention, and they have 20 years of protection from the filing date. There are also design patents. So those protect ornamental features. So like the design of the iPhone. And those have 14 years of protection. And then there are also plant patents that protect a new variety of asexually reproduced plants, and those have 20 years of protection. US standards of patentability. So in order for something to be patentable, it has to be novel, meaning that the invention is new and was not known, sold, or used by others, nor was it patented or disclosed in a printed publication. So if it's already out there, it's not novel. Useful, the invention must have a useful purpose and be operational, and it must be non-obvious. So the invention must be sufficiently different from what has been known to others in the field. So like a very simple example would be if you think of a cup, if somebody patented a cup and then somebody else decided to add a handle to that cup. We're all familiar with cups. It'd be pretty obvious to add a handle to that cup. Or another example would be changing the color of the cup. That would also be pretty obvious. Or changing the size of the cup. So a term that often comes up when determining if something is patentable is prior art. So prior art is any information for consideration when determining whether an invention is patentable. So it includes public information such as patents, publication, articles, products, etc., available or dated before the filing date of the application. Includes prior sales or public use as well. So when a patent is being examined, that patent examiner is looking for prior art to see if that prior art affects whether or not the patent is novel and not obvious. And then in the US, there's a 1-year grace period, which public disclosure by an invention or by an inventor will not be considered prior art against the patent. So like, for example, if the inventor publishes a paper that details the secret sauce of their invention on April 1st, 2024, they have until April 1st, 2025 to file some sort of patent protection. And then after that date, if they don't file anything, that publication will be considered prior art and the inventor can be barred from patenting that invention. So at USD, when we begin the patenting process, we typically begin with a provisional patent application. So provisional patent applications establish a priority filing date, and they're lower cost to file because they don't require formal patent claims. So a lot of times when we file a provisional patent application, we file what's called a cover letter, and that's usually a manuscript that the inventor has written up, and so it doesn't have those claims listed in it. Provisional patents, they're never examined, so a patent examiner never looks at them. They are never made public, never see the light of day. But it does allow that patent pending status, and they expire after 1 year. And so during that 1 year, you have to file what's called a non-provisional patent application in order to claim that priority filing date. And then that non-provisional patent application is what has the claims and can result in a granted patent. So the non-provisional patent application. So it includes a specification. So that's a description of the invention that typically talks about how to make and use the invention. It also includes claims. And so that's the most important part of the patent application. So it's what you consider to be your property based on the specification. So it's what is being protected. So non-provisional patent applications are examined by a patent examiner. And so they're going to determine if the patent application meets the criteria of being novel, useful, and non-obvious, and they're going to do that prior art search. And then the rights to the invention take effect once the patent office approves the application and issues a patent. So this is just like general flow chart of how the patent examination works for the United States Patent and Trademark Office, the USPTO. So when you file a non-provisional patent application, it gets classified to a specific art unit. And so the USPTO has different art units like organic chemistry. They have one for biotechnology, one for pharmaceuticals. My brother happens to be a patent examiner and he's in the lenses art unit. And so every time a application that comes in that deals with lenses, that would be assigned to his art unit. So then once it's assigned to the art unit, it's assigned to a patent examiner who does an initial review of the patent application, looking to see if it meets those criteria of being novel, useful, and non-obvious. And they do a prior art search. And if they come up with any issues with any of that criteria, they issue to the applicant what's called an office action, and that office action explains what the issue is. So then at that point, the applicant can either amend the application to satisfy the patent examiner, or they can argue why the invention still meets the requirements for being novel, useful, and non-obvious. And then that process can go back and forth between the applicant and the patent examiner until either the patent examiner is satisfied and they accept the patent application and they issue what's known as a notice of allowance. Then the applicant can pay an issue fee and then the USPTO grants the patent. Alternatively, the patent examiner can issue what's called a final rejection. And at that point, the applicant can decide to abandon patent prosecution, or they could also file a request for continued examination, or they could go through the appeal process as well. So granted patents. So it takes on average ballpark 2 to 4 years from the non-provisional patent application filing date to a granted patent. And then you get 20 years of protection from the filing date. So when you file that provisional patent and then those, 2 to 4 years while the patent's being examined, that does count against those 20 years of protection. And so ballpark average cost to file a patent to go through the patent prosecution process, it's $25K to $35K. But your costs don't end there. So once you have the granted patent, you have to maintain that patent. And so patent maintenance fees are due at 3.5 years, 7.5 years, and 11.5 years. Okay, so that was an overview of intellectual property and patenting in general. Now I'm going to talk a little bit about the Bayh-Dole Act and how it relates to university tech transfer. So the Bayh-Dole Act is a federal law that was passed in 1980, and it allows universities to own inventions resulting from federally funded research. So like research funded by like the NIH or NSF. And so what essentially did was it shifted IP rights from the government to the universities and allows the universities to patent and commercialize those inventions. And so the Bayh-Dole Act requires the disclosure of IP to the granting agency. So every time my office gets an invention disclosure that lists federal funding, I have to go into the federal government's platform called iEdison, and I have to upload that invention disclosure in order to remain in compliance with the granting agency. A good part of the Bayh-Dole Act for inventors is that it does require the university to share royalties with the inventors. So for example, at USD, it's 50-50 share of those royalties once applicable costs have been reimbursed, such as patenting to USD. And so the purpose of the Bayh-Dole Act, or the spirit of the Bayh-Dole Act, is to increase public benefit from federally funded research through commercialization. So the idea is that federally funded research is funded by taxpayer money, and so commercialization is a great way for the taxpayer to benefit from the research that they helped to fund. Okay, so now I'm going to talk about USD intellectual property policies and procedures. So our policy is guided by the Bayh-Dole Act. Then also the South Dakota Board of Regents BOR policy 4.91 on intellectual property. And then also USD's policy on intellectual property, which is numbered 6.018. Okay, so first I just want to talk about the purpose of USD's intellectual property policy. So it's to encourage the development of creative works for the best interest of the creator, USD, and the public. It's to nurture an entrepreneurial environment that encourages the creation and transfer to the public of the results of research and other scholarly activity. It's to provide for the timely disclosure and protection of property rights and innovations, whether by development, commercialization, publication, or any combination thereof. And it's for protection of USD intellectual property and transfer of USD IP for commercial application and benefit of the public. Okay, so first I want to talk about intellectual property ownership for employees that are employed by USD. So per the BOR IP policy, the BOR owns IP rights to inventions first conceived or first reduced to practice in the course of or as a direct result of employment duties. So if you're doing your normal assigned duties as a USD employee, the BOR, and you invent something, the BOR would own that. They also own inventions first conceived or first reduced to practice in the course of sponsored research. So if USD receives an external grant or contract from like the NIH or like NSF or American Heart Association, and that's used for research that results in invention, the BOR would claim that and then or own that. And then also the BOR owns inventions that were first conceived or first reduced to practice in facilities or using funds or other resources by or administered under the authorization of the board. So if you invent something in USD facilities and using USD funds, the BOR owns that as well. So when you were first hired at USD, you had a new hire paperwork, and in that paperwork, there was an agreement to assign intellectual property rights. So all employees sign that agreement to assign their intellectual property rights to the BOR. I do want to talk about copyright ownership a little bit because that comes up pretty frequently. So in general, the BOR does not claim copyright ownership of scholarly writings or artistic works. So like if you were to like write a book or write a textbook, the exception to that would be if like USD specifically commissioned you to create a scholarly writing or artistic work that would fall under copyright, and there was an agreement beforehand that stated that BOR would own the copyright. Then I also want to talk about IP ownership and students. So in general, students own their own IP rights with the following exceptions. So BOR owns IP rights to inventions created or reduced to practice by students contributed to sponsored or faculty directed research. So if you have like a graduate student in your lab, and the research results in invention, that would fall under BOR ownership. Same thing if you had like a summer undergraduate student working in your lab over the summer. Any invention from that would also be owned by the BOR. Another exception would be like if the student uses significant university resources. So like if they're like using USD lab space and they're like running the lights 24/7, using the utilities, using the reagents, the BOR may claim that IP as well, unless the resources are free to the public or applicable fees are paid. So like if they pay the hourly rate to use the confocal, for example. But in general, if students are using just like the general knowledge they gained through their classes at USD and they end up inventing something, they would own that IP. If you ever have any questions about IP ownership for employees or students, please don't hesitate to reach out to me, and I'll help work through that just to determine who owns the IP. Disclosure of intellectual property. So per the BOR policy, faculty have a duty to disclose IP that may have commercial potential or be subject to BOR ownership. And it's meant to be a collaborative effort between the Tech Transfer Office and the inventors to evaluate the invention disclosure. So you as the inventor, you're going to know that research better than anybody. And so you're going to have a very valuable, sorry, my phone is ringing. Okay. Very valuable insight into evaluating that invention disclosure. Okay, so I think I have an invention now. So what's the process for reporting an invention all the way through commercialization? So the first step is to reach out to the Tech Transfer Office, which is me, and then you fill out an invention disclosure, and I'll go into more detail about what that entails. And then we do an evaluation of the invention disclosure, and then at USD we have an IP committee through the USD Senate that provides recommendation on which invention disclosures USD should patent. And so if they recommend that USD should invest in the tech and patent it, we go through the patenting process. And then while that patent is being examined and once we have a granted patent, we go through the licensing process. So trying to license that patent out to a company. So the invention disclosure. So it includes the title of the invention, which is a non-confidential title. It also includes who the inventors are. I'll get into a little bit more detail about inventorship on a future slide. Also, it includes the invention stage. So is it like at the idea stage? Is there data? Is there a working prototype? Are you seeking funding? Also asks for the funding sources. So it's really important to report any federal funding that was used in the research that resulted in the invention, because USD needs to report that to the funding agency to maintain compliance with the Bayh-Dole Act. It should also include a summary of the invention, which is similar to like the abstract for like a journal article. The advantages of the invention, so like what makes it better than what's already out there. Limitations of the invention, so like what things still need to be worked out, the practical and commercial applications, companies interested in the invention, so either companies that you've personally talked to that have shared interest in the invention or companies you think would be interested. That's helpful for licensing. Also, any enabling disclosures that were made, which I'll talk more about enabling disclosures in a future slide, but enabling disclosures is essentially making your secret sauce public. And so that has some important implications. And then also it's helpful if you attach any complete descriptions to the invention disclosure. So if you have like any manuscripts written up, or if you applied for a grant, like attaching those like specific aims or that project summary is also helpful. Okay, so inventorship. So inventorship on a patent is different from authorship on an academic journal article. So this is something that comes up quite a bit. So just because somebody is listed as an author on your journal article doesn't mean that they necessarily meet the criteria for inventorship on a patent. So an inventor on a patent is a person who conceives of an original and non-obvious idea that develops or is capable of being developed into a physical reality. And so an inventor must contribute to the mental aspects of the invention. So like an example would be like a lab technician that does an assay and collects some really important data that gets included in the patent application, so that lab technician, they might meet the criteria for being an author in an academic journal, but because they didn't contribute to the idea, they just carried out the idea, they would not be considered an inventor. So a good way to determine inventorship is to ask yourself, if this idea had not been contributed, would the invention exist? And then the inventorship is determined by patent claims. And so it goes claim by claim. And so that also means that inventorship can change throughout the patent examination process. So let's say if you were determined to be an inventor on claims 5 through 8, and then the patent examiner ends up rejecting those claims, you would no longer be considered an inventor on that patent application. And so we work with our IP attorneys to help us determine inventorship when there is more than one inventor listed on an invention disclosure. And so they have a process that they go through to help us figure that out. Okay, then I also want to talk about enabling disclosures. So enabling disclosures is information made public that provides enough detail that someone skilled in the art can make and use the invention without undue experimentation. So it's disclosing your secret sauce and making it public. So like in an academic setting, common examples of enabling disclosures are like journal articles, also poster presentations. So like if your student gives a poster presentation at DFS, oral presentations, so like giving a talk at a conference, abstracts at conferences can contain secret sauce. Thesis and dissertations often contain secret sauce. Enabling disclosure can also be talking to others outside of the university and sharing your secret sauce with them. So if you have like a collaborator at a different university, or if you talk to somebody at a company, if you plan on doing any of those things, it's important you let my office know, because we can have those people sign a confidential disclosure agreement. So it won't be considered an enabling disclosure and won't count against patent protection. So in the US, there is a 1-year grace period before the enabling disclosure becomes prior art against the patent application. So if you publish a journal article, USD has 1 year from that publication date to seek patent protection. So enabling disclosures, they're just really important for determining the timeline for when USD needs to seek patent protection. And we'll never tell you not to publish or not to present at a conference. It's just nice to know when you plan on doing those things, just so we know when to seek patent protection. So evaluation of the invention disclosure. So first step is to determine if USD actually owns the invention. So like, for example, sometimes we might get an invention disclosure and it turns out that the inventor originally conceived of that idea at their previous institution. So in that case, USD probably doesn't own it. Also, enabling disclosures, so determining what's already been disclosed and any planned enabling disclosures, so we can create that timeline to determine when we need to seek patent protection. Also prior art search, so that includes doing just like a simple Google search to see what's out there, and looking through journal article databases like PubMed, doing like a patent search as well to see if there's anything that could count as prior art against the patent application. It's helpful if the inventors share some keywords to help with that prior art search, or if they are aware of anything that could potentially be considered prior art. Also, it's important to have a good understanding of the stage of the invention. So is it just at the idea phase? Has data been collected? What data still needs to be collected? How far are we away from having like a working prototype? Then also the commercial potential. So what problem does it solve? And so for the commercial potential, something that's helpful to determine what problem it solves, if it solves a problem, is going through our I-Course program, which I'll talk about more on a future slide, but it's a training program for customer discovery. So going out and talking to people that could be potential customers to determine what their problem is, and then using the scientific method to determine if your idea actually addresses that problem. So that's very helpful when determining that commercial potential. Okay, so at USD, we have an IP committee. So that's through the USD Senate, and there's one representative from each college plus a graduate student representative. And so they provide guidance on whether USD should invest in a technology. So should USD patent something? And so when it comes time to decide whether or not USD should patent something, we ask that the inventor gives a 10 to 15-minute presentation. And so they'll give a summary of their technology. They'll talk about the invention stage. Really important that you share where you are in the research, so what data has been collected, what still needs to be collected, because the further along it is, the less riskier it is. What are the advantages, and then what problem does it solve? So if you do go through the I-Course program, you're fine. That usually provides pretty good evidence for the problem that's being solved. So the USD IP committee decisions. So there's two main times that the IP committee meets, and that's when there's a new invention disclosure and we need to decide whether to seek patent protection. And then the other time is when we do file a provisional patent application and USD needs to decide whether to convert it to a non-provisional patent application, so a full utility patent application, because that requires significant more university funds than just filing a provisional patent application. So with a new invention disclosure, so the USD IP committee can decide to go ahead and file that provisional patent application. They sometimes also ask the inventor to come back to the IP committee with more info. So like, for example, they may request more data, or it might not be clear what problem is being solved. And so they might ask the inventor to come back in 6 to 12 months with more info. They could also decide to discontinue USD investment in the technology. So decide not to patent it. And at that point, USD has the option to return the IP ownership rights back to the inventor, which means that the inventor then can go out and patent it themselves. A big asterisk there is that if the invention received federal funding, the inventor would need to first get permission from the granting agency before USD can return rights to them. And then the second time the IP committee typically meets is when we have to decide whether to convert the provisional patent application, so they can decide to go ahead and convert that to a full patent application and file it in the US, because USD only files in the US. Or they could decide to abandon that patent filing and not convert it, and just let it expire. And a reason for doing that, like an example would be, let's say that the inventor hasn't worked on that research in the last year and has moved on to something different and is no longer pursuing that research. That would be a reason why USD would allow it to expire. So ultimately, USD patents technologies that have reason potential to be commercialized, and that's typically through licensing. And then the vice president of research makes the final decision on whether USD patents a technology or not. So the IB committee provides the recommendation, and then the VPR signs off on it, and typically they are in agreement on that. Okay, and then licenses. So let's say USD decides to go ahead and pursue patenting for an invention. So the next step would be to try to license that out to a company. And so that's transferring the rights to use, make, sell a technology to others in exchange for money, equity, or some other benefit. So we typically think of like a royalty when we think of licenses. So if we license it to a company and they end up selling a product that incorporates that invention, a royalty would be a percentage of the sales come back to USD. And then that gets split between USD and the inventors. So licenses can be exclusive or non-exclusive. So an exclusive license gives that licensee the exclusive right to use, make, or sell it. USD can't license it out to anybody else. And there's also non-exclusive, which means that if USD license does a non-exclusive license, they still have the option to do other non-exclusive licenses to others. But even if USD does grant an exclusive license to a company, USD still retains the right to practice the invention for academic research and for educational purposes. So we carved that out in the licensing agreement. And so you still have the right to continue that research at USD and still apply for grants. That doesn't prevent you from doing that. And then net income from licensing is split 50-50 between USD and the inventors after relevant expenses USD incurred to develop and commercialize the tech are reimbursed. So like, for example, USD incurred costs to patent the technology. And so once those patenting costs are reimbursed, then the income would be split 50-50 between USD and the inventors. The 50% that goes to the inventors is split amongst the inventors, and they decide how that gets divvied up. USD doesn't get involved in that, but if the inventors don't come to an agreement, the default is just to split it evenly amongst the inventors. And I also want to, something else I want to add for licenses is that USD can license to a company that maybe isn't affiliated with USD. But we also, if you have entrepreneurial interest and you want to start up your own company, USD can also license to you as well. If you're interested in that, and we can do a licensing agreement with you. I also recognize that most faculty become faculty because they want to work in academia and may not have entrepreneurial interest, but you might have a student in your lab that's interested in entrepreneurship. So that could be another option. If your student wants to pursue the technology through entrepreneurship, we could license to them, and then you could be some sort of like scientific advisor to that company. Okay, so now I want to talk about regional resources for innovation. So the first thing I want to talk about is the NSF I-Cores program. And so NSF I-Cores is a training program for customer discovery. So there's a national I-Cores, and then there's also regional I-Cores hubs. USD is part of the Great Plains Regional Hub through NDSU. And so for the regional training, it's a typical cohort. It's a 5-week training. It's all virtual typically. There's a couple courses that have been hybrid. But typically you have a workshop once per week, and it's usually a 3-hour workshop. And it's a 5-week period. And then you do 20 customer discovery interviews. So you go out and you talk to 20 potential customers to really try to understand what their problem is and how big of a problem it is, and then using the scientific method to determine if your idea actually addresses that problem. And you do all of that without talking about your technology, because that creates a sort of bias. And so a typical I-Cores team consists of a technical lead, an entrepreneurial lead, and an industry mentor. The technical lead is typically the faculty member. The entrepreneurial lead is typically the graduate students, so they're like boots on the ground. They're the ones going out and doing those customer discovery interviews. And then there's an industry mentor, and that's somebody with business experience that's not directly related to the research. Benefits of doing the I-Cores program: you become eligible for the national program, which is much more intense. You have to do 100 interviews, but you also get a $50,000 grant to help you do those interviews. So to travel to like conferences and trade shows to find potential interviewees and to pay student stipends. USD graduate students that successfully complete the regional training are eligible for up to a $1,000 stipend. So we offer $250 upon acceptance into the program, and then additional $750 upon successful completion. So attending all the workshops and completing those 20 customer discovery interviews. And then another perk is that USD has a subscription to LinkedIn Sales Navigator, which essentially opens up the whole of LinkedIn. You can reach out to anybody that has a LinkedIn account. You don't have to be a 2nd or 3rd degree contact, and you can send up to 50 messages per day, which is a lot more than what you get with just like LinkedIn Premium. So graduate students get access to that while they're in a training cohort. So if it's something you're interested, I have the QR code here that has the upcoming cohorts. USD will also be hosting a couple cohorts in 2025 as well. Other regional resources. So there's South Dakota Biotech. They have their Fast Launch program, and so that's up to $10,000 to support further development and implementation of your business plan. If you go through the regional I-Cores training, you're automatically eligible to apply for that $10,000. If you haven't, then you have to go through the fast launch customer discovery training. There's also the Government Office of Economic Development. And so that they have the Giant Vision Business Plan competition. So that's a $5,000 prize for the student competition, and then a $20,000 top prize for the open competition. I believe applications for that are due January 3rd, and then the competition this year is in February, and that's going to be in Pierre. GoEd also has proof of concepts funds, so you can get up to $25,000 for that. And then they also have their Dakota Seeds program, and that provides funding for internships for small businesses. There's also the USD Gear Center up in Sioux Falls, and that's on the USD Sioux Falls campus. So the second floor of the Gear is home to the USD Department of Biomedical Engineering, and they have laboratory space up there with equipment that community members can rent for like an hourly rate and utilize. Then on the ground floor, they have office space and lab space that small companies can lease. And then the idea is that once those companies become more established after a couple years, they move out of the Gear Center next door into the USD Discovery District, which is currently being constructed on that same campus. And that's has a planned opening date of early 2025. There's also the Small Business Development Center and also the Apex Accelerator that has different resources. I'll talk a little bit about SBIR and STTR. So SBIR, STTR is Small Business Innovation Research and Small Business Technology Transfer Programs. So this is non-dilutive funding to help develop tech. So there's 11 federal agencies that participate in SBIR, STTR. So like, for example, NIH, NSF, DOE. And then the awards are made to the small business. So for SBIR, you may sub-award to others, including universities. For STTR, you must. It's a requirement that you sub-award at least 30% to at least one research institution, such as a university. I didn't go into a whole lot of detail about those different resources because we do have an upcoming entrepreneurship workshop. That's going to be hosted by South Dakota EBSCOR, South Dakota Biotech, and the South Dakota Chamber of Commerce. And they're going to provide additional information about Giant Vision and other regional support programs like the Fast Launch program. They're also going to talk about SBR, and STTR. And then as an added benefit, students that plan on competing in the Giant Vision Business Plan competition are eligible for a $100 stipend if they submit an executive summary and meet with the presenter, Mel Ustad. He's a Giant Vision judge and has a lot of experience with like the SBIR program and different university and economic development initiatives in the state. So there will be a training in Sioux Falls on December 11th from 3 to 5. That'll be up at the Gear Center. And then there'll also be a training in Vermilion on December 12th. And there will be a light lunch provided at that training, and that'll be in the mug. So the QR code here you can use because you have to register beforehand. I think the deadline is December 4th for the Sioux Falls one and December 5th for the Vermilion one. But you can register using that QR code. Okay, so here is my contact information. I split my time between Vermilion campus and the Sioux Falls campus. So I've listed where I work at each of those locations. If you ever have any questions about intellectual property, about tech transfer, if you think you have an invention disclosure, please don't hesitate to reach out to me.